Here it is. As acting chair of the Children and Family Law Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with House Rule 67 and the governor's emergency order number 12 pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing on bills referred to the committee and scheduled in the House calendar for today. An executive session may be held on any bill referred to the committee at any posted time. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting complies with House Rules RSA 91A, and anyone who has a problem accessing the meeting should call 603-271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and/or rescheduled. Please note that all votes that are taken during this meeting shall be done by roll call. We'll start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there is anyone in the room with you during this meeting, which is required under the right to know law. Does everybody understand what I just read?
Yes.
I'm sorry, that was so perfect, but I missed all of it. You're gonna have to repeat it.
Okay, no. Thank you all. Madam Clerk, would you please call the roll?
Certainly. Children and Family Law Committee attendance. Representative Paul Schiller. Representative Belanger.
I am present in the LOB with Madam Chair and Representative John Lewicki.
Representative Cross. Vice Chair Representative DeSimone.
Good morning. I am here in the LOB rooms 210 to 11. I have my mask in case I get closer, but I am 10 feet away from Representative Belanger and Representative Lewicki.
Thank you. Representative Grossman. Representative Grossman.
She's connecting to audio. Hold on.
Good morning, everyone.
Good morning, Representative Grossman. We're taking attendance. I just called your name.
I am in my house in Exeter alone. Thank you.
Wow, 2 days in a row. Representative LeVay.
I am in my spare room alone.
Thank you. Representative Lewicki.
I'm at the LOB in the meeting room.
Representative Litchfield. Representative Long,
I'm in my home and I'm alone.
thank you. Representative Petrigno,
Good morning. I'm home in my home office alone.
thank you. Madam Vice Chair, will Representative Stephen Smith be joining us for Chair Rice?
As far as I know, Representative Brad Greenland will be joining us.
Just
I don't,
being the host for the meeting, I am just a staff member.
okay, thank you, Mr. Greenland. I do not know who will be subbing for Representative Rice today. I will check with staff and get back to you.
Okay, thank you. Representative Denise Smith,
Present. I am alone in my living room, but I have children. Sorry, my phone's ringing. My children are home and so is my husband.
thank you. Representative Wazir,
Good morning. I am home with 3 of my own children and my little brother.
thank you. Representative Yokella,
Yes, I'm home alone.
thank you. The clerk, Representative Ali Saya, I have contractors working, coming in and out, and a puppy. Thank you.
Thank you and good morning, everyone. Thank you for coming this morning. This morning, we're going to be trying to stay on task, and I am turning the electronics over to Representative Cody Belanger, and he will be the one to be answering hands and turning things over to all of who choose to speak on the various bills.
Madam Chair, if I may, Representative Altschuler just texted me that she cannot find her unique link. So if staff could send Representative Altschuler her unique link.
I will send it over to her now.
Who was that spoke?
That was Brad Greenland from House Community Services.
Thank you, Brad.
Madam Chair, Melissa Litchfield says she can't get on. Brad, can you send her one as well?
I will
Brad, can you
her
send
link
it
right
to, thank you. We're going to give it a few seconds for both of those people to be able to access the meeting, if that's okay with everybody else. I don't want anybody to miss anything because they can't get into the meeting. So if there is anybody out there who is a legislator on this committee and you cannot get in, please text either Representative Long or myself, and we will have the staff send you the link. Thank you.
Madam Chair.
Yes, Representative.
I noticed that Representative Altschuler has arrived.
Yes.
She just stepped away. If someone arrives, if they can let me know, and let me know if they're alone or whom they're with. May I have permission to call her name for attendance at this time?
Yes, ma'am, please do. And also, please, I think we had somebody else signing in too. Representative Yokella is now here. Representative Litchfield is now here. If you could call their names and they can answer your questions. Thank you.
Representative Holtschiller.
Good morning. I am
Good
here
morning.
in Stratham alone.
Thank you. Representative Litchfield.
Hi, good morning. I am in my home right now. I have my son and my husband here as well. They are in different rooms, but they are in the home as well.
And I do have Representative Yokella. Thank you.
Thank you, Madam Clerk. I think we're all set now to begin. Thank you all again for coming. And the first on the agenda was House Bill 494. I will open the bill and then we can check out who's wanting to testify and so forth. So, thank you again and good morning. I am Representative Deborah DeSimone. I represent Rockingham County, District 14. And I'm going to introduce my bill. This bill provides that the court shall not issue an order in a divorce proceeding that infringes on a party's constitutional rights unless the court determines there is no less restrictive means to achieve a compelling government interest. One of the reasons that this bill has been brought forward is because there is a need relative to the temporary relief and permanent restraining orders issued in a divorce proceeding. And we want to make it a more fair field of play, as it were. And I'm not taking it lightly. It is a very serious situation. So with that, I will ask Representative Belanger to allow Mr. Jay Markell, who assisted me in writing this, to speak on this subject.
Thank you. Is my mute, is my button working here? Can you hear me?
We can hear you,
Okay.
Mr. Markell.
Thank you, Madam Chairman. The basis for this bill is that it's to remedy what we view here as a couple of key statutory problems that exist in the divorce statute and the companion bill, which is 495. It might be there because the remedy is the same and the defect in the statute is the same. Let me explain. If you look at RSA 458-16, Section 1, what we do is we have a grant of authority which disregards the federal and state constitution. It allows a family court judge to disregard the federal and state constitutions the way it's being interpreted. Let me explain and give you a concise overview. It says 458-16 says after the filing of a petition for divorce, annulment, separation, or decree of nullity, the Superior Court, now obviously that's family court today, okay, may issue orders with such conditions and limitations as the court deems just and may, at the discretion of the court, be made on a temporary or permanent basis. Then it goes on. We have basically the same tracking language in RSA 461A10. The problem here is that, and this is a solution for an existing problem, is that it conveys, many courts are reading this as basically a license to do whatever they want to do without regard to the limits on the Constitution that are placed. By the way, what this bill does is that it deals with a compelling government interest. let me explain. The ability to issue equitable orders does actually come up against the federal and state constitutions. People do not surrender all of their constitutional rights merely because there is a petition for divorce or a parenting petition filed. Now, let's be clear. This exempts domestic violence petitions because there's a compelling government interest in protecting victims of domestic violence. There is and protecting children. And this also does not apply to abuse or neglect petitions. This does not apply to anything else like that. It also does not apply necessarily to parenting orders. And the reason why is because this bill says that it applies to enumerated rights under the federal and state constitutions. So it is a strict limitation. You have constitutional rights to parent, which arise within the Constitution, but they are not enumerated rights. And you impliedly waive that when you file basically a parenting petition or a petition for divorce, particularly where there are children involved, because then the state can assert a compelling interest in seeing that children are protected. The state can also assert a compelling government interest in seeing that parties are protected. So what this doesn't do, it lets courts issue orders that protect people. Okay, it does not disturb that at all. Anti-harassment orders are still in place. Domestic violence orders are still in place. Courts have broad general discretion to do anything within reason that will be a sustainable exercise of discretion. By the way, it's worthy of note when you look at restraining orders, particularly under RSA 458-16, when we're talking about entering premises and things like that, staying away from people's work, which is the same thing under RSA 468-10. What is not a restriction within the statute is entering a house of worship. So in other words, the statutes actually do impliedly recognize the First Amendment, which is that you have a right of freedom of worship. So what we're merely saying with this is that the court is still free to craft individual remedies that address the needs of a case. What it just says is that if you intend to infringe on a constitutional right, which is already identified within the Constitution, all we're saying is, Your Honor, please identify the right that is being infringed. Tell us why this is necessary to achieve a compelling government interest, and tell us why there is no less restrictive way of achieving this compelling government interest, and just make written findings. That's all you really have to do. It's no burden on the court. It clarifies things. It also puts parties on notice as to what people can do and what they can't do. There seems to be a widely held misconception that somehow there is a family law exception to the federal and state constitutions. There is not, okay? While the Constitution does not come into play as often as it does in, say, criminal cases, nevertheless, we do have these rights. Once again, this is not a domestic violence statute. All it does is this does not infringe on the rights of victims. It still protects victims. It just says to the court, let's apply the law, and that there are constitutional limitations. So you can view this as curative. What it does is that it really just clarifies what the court's discretion is, and that court's discretions have limitations. Now, one of the things I did earlier this morning was I emailed the committee not only a copy of the two statutes so it can read it, but I emailed a copy of the Schacht decision, which came out of the Massachusetts Supreme Judicial Court, which deals with the First Amendment. and it talks about prior restraint, and it gives a good overview of how important rights are. And this is in the family law context. So, for example, for example, in our parenting plans, we say you can't, if you're a parent, disparage another parent in front of that child. And that's going to stand. And the reason why it's good law is because the state has a compelling government interest in seeing children not being emotionally damaged by a parent denigrating another parent in the child's presence. That's going to stand up. That's fine. These are just some examples. Now, from the real world, let's look at whether or not this is simply a solution looking for a problem. Well, I can tell you that I'm just one person. And over the last 18 months, I have received orders outside of the restraining order context. Because note that this statute not only applies to restraining orders, but all orders. The reason it's in the harassment statute, is in the restraining order statute, is because that's where you may find a lot of violations to occur. But please note that it applies to all orders. So, for example, when you have two bickering parents and they don't seem to be able to arrive at anything, should a court order prior restraint by saying something like the parties, for example, may not discuss prior issues, must be non-sarcastic, civil, and forward-looking in their discussions. Now, that became an order of the court outside of a restraining order. Now, that is what's called prior restraint, which gets very strict scrutiny under the federal and state constitutions and under relevant U.S. Supreme Court law. And that's why I've got the Schack decision down there for you, so you can read it and get kind of a better handle on how courts view this. The New Hampshire Supreme Court also deals in prior restraint, which is basically a form of censorship, okay? We come down in this society as against censorship in most all circumstances. Interestingly enough, while many of the violations would probably be of the First Amendment type, freedom of speech, things like that, nevertheless, I had one which actually violated the Eighth Amendment to the federal Constitution and Article 18 of the New Hampshire Constitution, in a situation where a man was taxed alimony and child support in excess of 100% of his income. Now, the background on this is that the man agreed, committed domestic violence, and he went to jail. Okay, no question he did wrong. But the court, in an independent order, okay, for alimony, after first finding out he had no ability to pay alimony, nevertheless decided to change its course and direction and actually taxed him alimony to 100% of his income. And I think you would find in the orders it was a strong consideration that he had committed some domestic violence. When we pointed out to the court that this was a violation of the Eighth Amendment, which was at that time in 2019 made applicable to the states for excessive fines, and by the way, which already existed in New Hampshire under the excessive fines statute, under the excessive fines constitution, under the New Hampshire Amendment, the court actually backed away from the order. Now, I have another case where in the restraining order context, a court issues an order that says the parties may only communicate through parenting applications, through a parenting application such as Talking Parents. Now that is fine because that's a legitimate time, place, and manner restriction. Okay, and courts can do that with no problem and they don't get strict scrutiny. But the court said they may only discuss parenting issues. Now, the client in this particular case had a very good lawsuit against the other party because of destruction of property and a few other things. under that court order, he can't even settle a case without being cited for contempt. And by the way, contempts in the state of New Hampshire, do a couple of things. Number one is that they stain a person's court reputation. Number two, they may trigger attorney's fees. Number three, in extreme cases, you can be sent to jail. Now, carry this one step further. Supposing somebody, and by the way, please be aware, the power to contempt and order to jail is within the discretion of the court. So can you imagine engaging in otherwise First Amendment and New Hampshire protected speech?
1 minute, please.
Okay, non-threatening, non-harassing. And can you imagine being sent to jail on something like that? So what this does is this cures the existing defect that exists in the two statutes. And all it says is, Judge, if you're going to infringe on a constitutional right, which you might be able to do, tell us why you have to do it. Tell us why there is no other less restrictive way of doing it. And please identify the right that you're going to infringe on. That's really kind of it in a nutshell.
Thank you, Mr. Markell. Any questions from Mr. Markell? Representative Long, you can unmute yourself.
Thank you, Madam Chair. Thank you, Attorney Markell. I don't deal with this every day, so I get lost a lot of times when you testify and keep adding cases. But I pick up what I can. So looking at this bill, so the court is responsible for identifying a right infringed.
Correct.
Correct? So if the court deems that the right isn't infringing any state or federal constitution, but a party to the proceedings do, how would that work?
Okay, well, when you say how would that work, can you I'm trying to answer your question.
Well, I disagree with the judge, but it doesn't give me the option to say that my rights being infringed. That's up to the judge to identify my rights being infringed.
Well, no, you have a right to make, you with all due respect, Representative Long, you absolutely have the right to make that argument.
Okay, where does it say that in here? Or where does that say that in 458 or any other statute?
Well, it doesn't, because what you're doing is you're making an argument to the court. In other words, if a judge, so in other words, here's the way this would typically play out. One party submits a proposed order or recites a set of circumstances that they want the court to take a certain action. But it is always the government's burden, and this burden never shifts to an individual, okay, under well-settled law, to justify actions that violate the Constitution. This is always a government burden. It is never, ever on a party, okay? That's the history of constitutional law when the government or a court infringes on a right. So to answer your question directly, Representative Long, the court says, I'm going to do what? I am going to, for want of a better term, I am going to place content-based restrictions, okay, on what you say to him or to her or whatever. I'm going to do that. You cannot talk about this. You cannot talk about that. You cannot talk about this. And then if it's in there and the party is aware of it, and hopefully that would be in the statute, because one of the key portions of the statute is to give reasonable notice to a party as to what the law is. That's well-settled law. So they come in and they say, but Your Honor, I have constitutional rights. And by the way, Your Honor, I see that under this statute, if you're infringing on my constitutional rights, can you please tell me why you're doing it and why there is no less restrictive way? And then it would be up to the court to justify the restriction. To your question?
A follow-up?
Yes, Representative, follow up.
Thank you. Now, with the newly added constitutional right of privacy to New Hampshire's Constitution, I I would suspect that that could be tied into anything you're asking me to do. Whether or not you're compelling me to release whatever income, although that's in another statute. But my mother pays for my oil heat, and that's you're asking me for that. Do you see a potential? Added burden with respect to the right of privacy in these, in these infringements?
No, because remember this. First of all, there's no undue burden on a court. This is actually handled in a few sentences, and that's not hard to do. The other thing is that I don't see a right of privacy here. Let me explain. That's governed differently, okay? And that's governed by different statutes. For example, financial affidavits, when filed with the court, become confidential as a matter of law. That is not an enumerated right under the federal or state constitutions. This is actually fairly narrow, okay? And I hope I'm answering your question, Representative Long.
Yeah, if I may.
For the follow-up?
Yeah, I mean, maybe that was a bad example. I'm thinking of my right to have a gun in my room. And to me, that's my private belonging, and that's my privacy that I want to keep.
You have that? Yeah. I'm sorry, go ahead.
And I'm being compelled to divulge that.
Okay, that doesn't infringe on your Second Amendment right. I mean, that's a good question, and I'm going to try to answer it as best I can. First of all, let me restate. This does not apply to domestic violence petitions, okay?
Correct.
This does not apply to domestic violence orders, which, by the way, cut across a wide swath of constitutional rights, and they are necessary to achieve a compelling government interest. So this doesn't apply there, okay? Well, if you want to have a gun in your house, that's the Second Amendment. That's your right to keep and bear arms, assuming you are under no legal disability to do so, okay? Could a court, for example, issue orders with respect to firearms? Actually, they probably could if it was somehow necessary to protect the best interest of a child. For example, and this is, by the way, you're asking a great question here. Okay, so let's look at the two rights. First, in terms of parenting in the best interest of the child, remember that we always have that. Okay, because protecting a child from danger is a compelling government interest. At the same time, we have a conflict. We say that Representative Long says, I own a gun, but Judge, you can't take away my gun rights. No, you're not. You can keep and bear, but a time, place, and manner restriction would be considered valid and not subject to an enumerated right. For example, a court issues an order because guns are an issue in this case for some reason. I'll give you a hypothetical. Judge, opposing party here leaves guns laying around the house loaded, okay? I'm seeking an order to prevent the other side here from leaving guns laying around loaded because they have parenting time, and this is a 5-year-old child who may get into a gun and hurt himself, okay? So if I'm the judge, okay, I am going to, if it's a second, and then Representative Long says, but Your Honor, I have a Second Amendment right to keep and bear arms. And if I'm the judge, I'm going to say you do have a Second Amendment right to keep and bear arms. However, I have a competing interest here, which is the best interest of the child, okay? And so if I have to infringe upon and by the way, it would be a mild infringement, okay, on your right to keep and bear. Your right to keep and bear does not extend to leaving a loaded gun laying around the house where a 5-year-old can get it, okay? So I am going to say that this would be necessary to achieve a compelling government interest. If I'm the judge, I'm going to rule as follows. I'm going to say the party in question here asserts a Second Amendment right to keep and bear arms, but I hear credible evidence that the party who asserts the Second Amendment right leaves a loaded gun around the house where a child might be able to access it. Okay? To preserve the best interests of the child, I make the following ruling. I'm going to say that I recognize that a Second Amendment right exists. However, this does not meaningfully infringe on the right to keep and bear, but it's necessary to protect the best interest of the child for him to keep the loaded gun out of reach or safely stored while exercising parenting time or while the child is in the house. Okay? And there's no less restrictive way for me to do it. That's my order as a court. Okay? And that's a good example. And thank you for giving me a fabulous example of why these statutes are necessary.
Okay, thank you, Attorney Marco. Thank you, Madam Chair.
You're welcome, Representative. Next, we have Representative Altshuler seems to have a question. Do you? You can unmute yourself and ask your question.
Thank you, Madam Chair, and thank you, Attorney Marco, for answering my question. It's delightful to hear some sense being brought to the New Hampshire legislature about gun violence prevention. So for that, I thank you very much. But I don't know, I'm not sure how that necessarily applies to this bill. You used an example in your testimony of someone being barred from being able to practice their religion because of a restraining order. And I don't know that did you have examples of that ever happening in New Hampshire? So that seems rather extreme.
Well, no, what I respectfully will restate, Representative Altshuler.
Thank you.
Okay, when you look at the restraining orders, I'm going to point out RSA 458-16, and I'm going to first, and I'm going to say when you take a look at RSA 458-16, and I'm going to say 458-16-1, B, C, and D. And when you look at B, you have enjoining any party from entering the premises wherein the other party resides upon a showing of physical or emotional harm would result. Enjoining, and then C, enjoining any party from contacting the other party or entering the other party's place of employment or school. And then below that, enjoining any party from harassing, intimidating, or threatening the other party or other party's relatives, regardless of their place of residences or other party's household members in any way. Now, why, if we respect the Constitution, if there's no respect for the Constitution, why wouldn't we add this language and say enjoining any party from entering the place of employment or where the other party worships? Because if you did, because what happens if somebody else worships there as well? So in other words, that's an implicit recognition that that's freedom of religion. Okay. Now it creates a different dynamic under other circumstances, but if there were no respect for that, why would we have it? Now we have practically an identical track on RSA 461A10, which also says 461A10-1, okay, B and C, which basically track the same language. Entering the premises, contacting or entering the other party's place of employment or school. Once again, no restriction on attending church or synagogue or any other place of worship.
Okay, may I follow up, Madam Chair?
Follow up, yes.
Sure. Actually want to go in a different direction. I thank you for your thoughts on that interpretation, but I'd like to go to the actual language of the bill.
Okay.
And on lines 6, basically from the word identify on line 5, all the way to the word objective on line 7.
Okay.
It appears that this bill is intent on creating a formula and perhaps even a form for judges to fill out that would have to, would create a very specific way of giving orders rather than their thoughtful narratives. And that seems like that's the sacrifice that is being asked, is that you're taking away judicial discretion and judicial creativity in the way that they're applying the law, and making them fill out a form?
No, actually not. What this is that this simply goes right into the narrative. Any judge sitting in this state should have taken constitutional law or should be familiar with it as a matter of going to law school. Okay, number one. Number two is that this language actually tracks well-settled United States Supreme Court constitutional law, which is called strict scrutiny. Strict scrutiny comes, and this is basically what this law is, okay? This is where it comes from. I did not invent this. In fact, if you look at the case I submitted called the Schacht case, okay, you're going to find strict scrutiny in there, okay, because this is well-settled law. I didn't create this, okay? And so it's simply a test, and it says, what's the necessary, if I'm going to infringe on a constitutional right, the narrative is going to be something like this, and it goes right, the order would be something like this and goes right into the court's narrative. It's going to be petitioner seeks A, B, C, D, E, F, G, that they not be allowed to fill in the blank, not be allowed to discuss the child with third parties, not be allowed to whatever. I grant this, noting that the First Amendment does blank and has what's called prior restraint, okay? However, based on the facts of this case, which may mildly infringe on a right. However, I find as follows. 1, the parties have a history of blank. 2, the party in question for whom this restriction applies has a history which is unchallenged of blank. The compelling interest here is that to protect or whatever, okay, to protect the interests of a child or protect whatever it is, which is a compelling government interest. And number 4, there is no, having considered all the options, there is no less restrictive way of achieving this compelling government interest, okay? And that is the Supreme Court test. And you'll see it in the Schacht case, okay, that I emailed to the committee, because that's a very good recital of First Amendment. Now, most of the violations, I think, that in terms of orders and constitutional infringement that occurs in the First Amendment context, either within a restraining order context or outside of it, okay? And what you have here in your present statute is that we are telling the courts, okay, on what I referenced before, we are telling the courts that, guess what? The Constitution really doesn't apply to you, okay? That there is a family law exception to the federal and state constitutions, when in fact there is no such exception. That's my point in dealing with this. So this is curative. Representative Altshuler, have I answered your question?
I have the information I need. Thank you.
Okay.
Thank you. Any further questions? Thank you, Mr. Markell.
My pleasure.
Our next person who would like to testify is Erin Jacina. Erin, you can unmute yourself.
Great, can you hear me?
Yes.
Okay, thank you. Good morning, Madam Chair and members of the committee. My name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. For more than 20 years, the Domestic Violence Project has been representing victims and survivors of domestic violence, sexual assault, and stalking in their protective order cases, as well as their high lethality divorce and parenting cases. I'm here today to testify in opposition to House Bill 494. With respect, I'm still very unclear as to the issue this bill seeks to correct. which constitutional rights exactly have been infringed upon by utilizing this type of restraining order. And right now we're talking about the restraining orders under RSA 45816, so under the divorce statute. Attorney Markell provided some very nuanced examples where half of the action by the court is permissible in his opinion, but the other half is not. If this bill were to become law, I'm not sure how judges would even apply it. This is exactly a solution looking for a problem. The language of this bill is far too technical for the average person accessing the family court to understand. As practitioners, even, we reviewed this bill and had difficulty pinpointing the objective and the process for which that objective would be achieved. So these restraining orders, the ones that we're talking about today, we're talking about restraining orders under the marital statute and under the parental rights and responsibilities statute. So these types of restraining orders are less restrictive than other civil protective orders. And I think that may be causing some of the confusion. So these orders can be used in cases where perhaps a party doesn't qualify for a protective order under RSA 173B, which is the domestic violence statute, or simply doesn't want the protections offered under that statute. But it is clear something needs to be in place to act as a buffer between the parties in a particularly high conflict case, or even in a case involving domestic violence. This type of restraining order is often used to settle cases. Again, one party may be willing to forego a domestic violence protective order in exchange for a marital or parenting restraining order if it means settling their divorce or parenting case. So again, I understand that the intent was to create clarification around these types of restraining orders, but based on the testimony today, based on our reading of the proposed language of the proposed bill, I think it's going to create further confusion. And again, this bill is seeking a solution to a problem that does not currently exist. So therefore, we respectfully request that this committee vote inexpedient to legislate on House Bill 494. Thank you.
Thank you, Ms. Jacina. Any questions for Ms. Jacina? Seeing none, we'll go to the next person asking to speak, Representative Albert Baldessaro.
Thank you, Madam Chair. For the record, Representative Al Baldessaro, Rockingham County, District 5, which is Londonderry. I am calling in support of HB 494, and I was honored to co-sponsor this bill. 9 out of 10 cases of restraining orders, the person that the restraining order is against doesn't even know until the cops show up to his door and say you have to leave, and then 10 days you get a hearing. The rights, people's rights are being abused because within that 10-day period, guns are taken away, depending on the issue and the court order from the judge. And, you know, you're removed, and I've sat on many cases here. I'm one of the original representatives on the redress caucus. And we've heard cases of over religious cases where one parent wanted the kid to go back to the religious school and the other parent that had the custody didn't want it. There are many cases out there that rights are being abused. Now, how do I know this here? Because I'm a victim of one myself, okay, on a restraining order. Didn't know anything until the police showed up and said I have to leave a house. I was fortunate to fight it, got it dismissed, and got custody of my daughter in a divorce case. Children are used as political pawns, and all it takes is for a parent to go and say that they fear for their life, and a restraining order is issued. This is a no-brainer. This legislation, the system needs to be fixed, and I want to thank the chairman for bringing this bill forward, because it's going to fix something that is broken in the family court. We all know that. And there is a bunch of us legislators that sat in family courts and watched and heard and seen what goes on these restraining orders. So I thank you for bringing this forward, and I was honored to co-sponsor. Thank you.
Thank you, Representative Baldessaro. Representative Altshuler has a question for you. Will you take it?
I sure would.
Thank you.
Thank
You can unmute yourself, Representative.
Thank you, Madam Chair, and thank you, Representative Baldessaro, for entertaining a question. I'm curious because I think that, have you possibly mixed up the two different kinds of restraining orders? Because what we've been talking about is not a restraining order that would remove someone from a house, nor take away their firearms. We're talking about parenting plans. So is it possible that maybe this is not that bill?
Not at all, because when you take away a parenting plan, you're actually taking away other rights because you're moved out of the house. And I know it firsthand because I was involved with a parenting plan. But it took me 10 days of being out of a house and everything else and losing a lot of my rights until I got back into court and got it dismissed.
May I follow
Thank you.
up?
Follow up?
So this bill seeks to compel judges to clarify why they are doing what they are doing in a detailed way. And so I don't understand how you're conflating taking away firearms from someone who is a danger to themselves or their family and them deemed to have that process taken, with this bill that is asking the government to explain that in great detail. So there's no police involvement unless someone is actually committing a crime.
Is there a question in there?
The question is, do you understand that there's no police involvement unless there is a crime?
That's any type of restraining order. The police are involved because they go to your house and deliver it. There was no crime in my case. It's just somebody with fear for life that goes to the court and says that I have a problem. Then a parental plan is put in place, and you're moved out of the house. So I don't understand where you're going with that there, because it's happening all the time. You know, with the parental plans to a restraining order.
Thank you. Any further questions? Thank you, Representative Baldessaro.
Thank you. Have a good day.
Thank you, you as well. The next person we have to testify is Mr. Richard Head.
Thank you, Madam Chair. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I think there is a fundamental misunderstanding as to what the statute allows, because the statute does not create an exception to the Constitution. The legislative body cannot create a statutory exception to constitutional rights. So there's nothing in the current statute that expands a judge's rights relative to the constitutional rights of the people in front of that judge. So, I think there's a fundamental premise that is not the case. A judge is still bound by the Constitution, and if a statute is unconstitutional, the court would have to find that the statute is unconstitutional and then simply cannot apply it, or would have to extract out the unconstitutional provisions of the statute. The other aspect of the bill that I think is inaccurate is that it applies. It talks as to strict scrutiny, which is, as Attorney Markell stated, one of the ways in which you review constitutional provisions. And for some constitutional provisions, strict scrutiny is the appropriate level of review. But there are in fact 3 levels of scrutiny relative to constitutional provisions, and it depends entirely upon the circumstances and the constitutional provision involved. And the bill as written does not limit the review to, or the issue to, the First Amendment, but talks about all constitutional provisions, state and federal. And there are in fact 3 tiers of review: strict scrutiny, intermediate scrutiny, and rational basis scrutiny, depending on the constitutional provision involved. So this would actually create a standard for all constitutional provisions that would apply the strict scrutiny standard, which is not constitutional law. And then my final point is that this does not change anything. The courts are still bound by the Constitution. The court's decisions are subject to review, as would occur under this bill. And if the Supreme Court makes a determination that a ruling was unconstitutional, and similar to the decision that Attorney Markell provided you, the Shack, Massachusetts decision, it applies the same way in New Hampshire. The Supreme Court evaluates the decision, determines whether or not a constitutional provision has been violated, and if so, whether or not under one of the 3 appropriate tiers of scrutiny, whether there was a basis for which that could occur. So there's nothing in current law, and the legislature has not authorized through current law judges to violate the Constitution. And in fact, this bill as written would incorrectly apply the level of scrutiny relative to various constitutional provisions, given the breadth of the bill. So I mean, I testify for information, but I think there are some at the foundation of the proposal, some misunderstandings, and I would be happy to answer any questions. Thank you.
Thank you, Mr. Head. Any questions? Seeing none, thank you very much, Mr. Head.
Thank you.
And we will close this hearing. We had 1 in support, 3 opposed, and 2 testify. And we will close this, and I'll give the clerk a minute to get things together. And when she nods her head, we will go on to House Bill 495.
Sorry, Madam Chair, we actually had 4 people testify.
I apologize. I was reading from my sheet.
Yeah.
Yes. And the sheets are not always updated. I stand corrected. Thank you, Representative Altschuler.
Yeah, I know you get those sheets
correction.
first thing in the morning, right?
Right. And then people raise their hands
Yeah.
that haven't signed in. So yes, we did have 4. Thank you, Representative Alisea. We will now open the next hearing. House Bill 495. I am the sponsor, so I will read the bill and we will move on from there. Thank you. This bill provides that the court shall not issue an order in a parenting case that infringes upon a party's constitutional rights unless the court determines there is no less restrictive means to achieve a compelling government interest. And with that, I will be happy to turn the testimony over to Mr. Markell. Mr. Markell, you can unmute yourself.
Hi, can you hear me?
Yes, we can now. Thank you, Mr.
Yeah,
Markell. Go ahead.
In regard to the previous testimony, I'm well aware of the 3 levels of constitutional review. There is what's called rational basis, there is what's called intermediate scrutiny, and there is what's called strict scrutiny. What we're talking about here is strict scrutiny, and the reason why is because if it infringes on a right. Now, bear in mind, okay, a couple of things. Number 1 is that rational basis says that all it has to do is basically for economic and social legislation. Okay, so in other words, is it constitutional to regulate certain kinds of businesses? We heard from the judiciary, so let's discuss what these levels of review are and try to keep it real and try to keep it meaningful. Okay, number one, rational basis review under the Constitution is things like economic and social legislation. Okay, economic and social legislation is, can they issue, for example, a business, require you to have a business license to give to open a business? The answer is yes. Can they require barbers to have licenses and pass levels of competency to get that? The answer is yes. Can government regulate certain businesses to certain extents? And that gets rational basis review. In other words, is it connected to a rational government objective? Intermediate level of scrutiny, okay, are things like time, place, and manner restrictions. Okay, so in other words, when you say you have visitation in a parenting class, in a parenting program, okay, you have this level of visitation, it's on weekends, it's this and that, okay, for example, or better yet, in terms of speech and parades, you have to get a permit, okay, to manifest your right of free speech. Your parade permit is good for X days or X hours between this and this and this. Okay, those are time, place, and manner restrictions, and they get a lesser, more deferential standard of review. What we're talking about here are things like content-based restrictions. That's prior, okay, that constitutes prior restraint. When a court says, so in other words, and judges should be familiar with this. So when somebody says, you can't tell me that I can't talk on this time, place, or manner restriction, the court simply says, okay, this is a time, place, and manner restriction, and it's not subject to this kind of review, okay? What we're talking about is things like content-based regulation and things like that. So I understand what I heard before, but those are basically the three levels of review that we're talking about. Number one, this does not constitute a burden on the court system at all. Judges should understand it. If what I'm saying here is that you have, and what I'll restate in 461A10 is that you have such conditions and limitations as a court may deem just. Okay. Now, the practical aspects are that courts will say, yes, I can. And by the way, in terms of it being a problem, a solution looking for a problem, perhaps I should redact heavily some orders so that you should see them, because eliminating courts, eliminating judge names, and eliminating parties, because I have the orders. So this is a problem, and it's not just a solution looking for a problem. I would want to check further to see if that's permissible. But these are the kinds of things that are out there. And the other thing is that the notion that you can be able to go to the Supreme Court and get things adjusted, okay, as a practical matter, this provides a standard of review. Okay, so in other words, Judge, this is what happened in the case. Were my constitutional rights violated? So in other words, was there an error of law involved, which is a different standard of review from the unsustainable exercise of discretion to the prejudice of a litigant. That's basically where we're at. This is, I think, this is a mild remedy. It doesn't tell courts that they can't do things. All they simply have to do is justify it. If a court disagrees and said, this does not apply, this simply calls upon the court to exercise the knowledge that it ought to have. As far as it, once again, we heard from New Hampshire Legal Assistance, we respect their positions, but this is not a domestic violence issue. It simply isn't. Domestic violence travels under its own authority with its own levels of protections. This is simply a protection of constitutional. This is simply a vehicle by which courts and parties get notice of constitutional rights and are able to aggravate and be able to explain their orders. That's it.
Thank you, Mr. Markell. Any questions? Seeing none, we will go on to the next person who wishes to testify. And I'll call upon Erin Justina. I apologize. Erin, you can unmute yourself.
Okay, thank you, and no worries. Again, my name is Erin Justina. I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. And Madam Chair, with your permission, House Bill 494 and 495 are identical. They're just placed in two different statutes. So my testimony would be the same for 494 as well as 495. So in the interest of time, I will not reiterate that testimony if that's all right with you, Madam Chair, but I do just have two follow-up points.
I'm perfectly fine with whatever you want to do. Your testimony is important. So it's
Thank
totally
you.
up to you how you want to testify. Thank you.
Well, hopefully everyone will remember 494. So I will just reiterate that testimony. But I do want to clarify and respond to Attorney Markel's position that this is not a domestic violence issue. It is a domestic violence issue. We heard from a representative who said that these types of restraining orders remove people from the home and guns are removed, and that is simply not the case. Respectfully, that is not the case. I believe what he is referring to is protections that are afforded a victim under RSA 173B or under the stalking statute, which is RSA 633-3A. So in those situations where a domestic violence victim goes to court and files a petition and the court issues a temporary order in that situation, then yes, if guns were involved, if there are guns in the home or other weapons in the home, in that situation, yes, a police officer is going to show up at the house, is going to remove the person from the home, and is going to remove those weapons. That is absolutely what happens under those two statutes. That is not what is happening in this situation. Guns are not removed. You're not removed from your home unless, as Representative Altschiller commented, you are not getting arrested for violating this restraining order unless you are committing a crime, which you would be arrested for anyway. So if somebody assaults someone, regardless of whether or not there's this type of restraining order in place or another type, you're getting arrested because you committed a crime. This is a civil restraining order. Again, police involvement is not happening unless you are in fact committing a crime. If you violate a restraining order under 458-16 or under 461A, you're dealing with a contempt motion in court. So I wanted to address that point, but also to Attorney Markel's point that it's not a domestic violence issue. These restraining orders, as I mentioned in my earlier testimony, are often used in settling domestic violence cases, or I should say domestic violence involved divorce or parenting cases. So as I mentioned, you may have a victim who does not wish to seek an order under 173B. There are many reasons why a victim may choose not to do that. Perhaps she doesn't want to have another court-involved case, perhaps does not want to share the very, very intimate details of a sexual assault, perhaps does not want to access that protection because it may escalate the abuse by her abuser. It could increase her lethality risk. So an alternative for a domestic violence victim is to get one of these restraining orders in a divorce and parenting case. One of these restraining orders, which yes, perhaps is less restrictive, will be the deterrent for that abuser to leave the victim alone and to cease the abuse. So I respectfully disagree that these are not domestic violence related restraining orders. They are. We use them in cases to resolve cases, to settle cases for our clients that don't want to go through the 173B process, but want something in place to make the abuse stop. And these do that to some extent. So for those reasons and for the testimony that I offered under House Bill 494, I respectfully request that this committee return a vote of inexpedient to legislate. Thank you for your time, and I'm happy to take any questions.
Thank you, Ms. Jacina. Do I see any questions? Seeing none. Oh, I'm sorry, Representative Lewicki.
Thank you, Madam Chair, and thank you, Ms. Vecina. I am trying to understand how your testimony applies to this bill, whether it's a domestic violence order or any other order. What reason could there possibly be for not putting in a constitutional justification?
I'm not exactly sure how these how the language of this bill is infringing on somebody's constitutional rights. And I think it's the language of this bill that is confusing. As I stated in my earlier testimony, just the plain language of this bill is not accessible to the general public. I think it's going to be difficult to apply. You heard Mr. Head testify for the reasons that, and I will agree with his testimony in response to that question.
Follow up.
Thank you, Madam Chair. I am a college dropout, and I have no difficulty reading this language. Why would you assert that somebody isn't able to understand it? It looks like plain English to me.
Respectfully, I will answer your question that most people have a very low-grade reading level. I think like the average is somewhere around middle school or high school. And so you're having general public accessing and people who don't speak any English at all, low-income people seeking services or justice through our family court system and trying to review our laws. These are not easy to read. They're not accessible. And the language of this bill is not accessible. So I appreciate that the reading to you is very plain. It is not to me.
Thank you, Ms. Jacina. Anyone else have any questions? Seeing no further questions, we'll move on to the next person who wishes to testify, Mr. Richard Head.
Thank you, Madam Chair. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. And thank you for giving me the opportunity to testify again. As was stated, this is very similar to the last bill, but I'll repeat myself a little bit and I apologize. The bill would provide that the court has to identify any rights being infringed under any enumerated federal or state constitutional provision. And as I said before, there are 3 levels of scrutiny depending on which enumerated constitutional provision is at issue. It could be strict scrutiny, which is specifically identified in the bill. There's intermediate scrutiny and there's rational basis. This would provide that all orders issued under 173B, if there is a potential infringement on a constitutional right, would have to be subject to strict scrutiny, which is simply not the standard for all provisions. Secondly, it does not accomplish anything that is not already current in existing law. As I said, with regard to the other bill, the statute that's targeted here, RSA 173B, does not create any exceptions to the Constitution. The legislature is simply not authorized to create exceptions to the Constitution and is not authorized to give judges authority to violate constitutional provisions. The judges are always subject to the Constitution. And so anytime a court, whether due to the fact that a particular area of law is not well described, so the Supreme Court needs to issue a ruling for the first time relative to the constitutional authority to issue a type of order, or that the court has already the Supreme Court has already described when certain limitations are constitutionally authorized. That already exists in current law. And as the last sentence of the bill says, any party aggrieved by an order not meeting the standard may petition the court to have the order modified or vacated. Anytime if for whatever reason a constitutional right is infringed upon by a court's order, the party always has the right to seek reconsideration of that order or to appeal to the Supreme Court. And the Supreme Court on a constitutional issue does not look at it as an unsustainable exercise of discretion standard, but looks at all constitutional issues new and bases it on its own review, not upon the trial court's review. So there is no difference in the sense of how the Supreme Court looks at constitutional issues with or without regard to this bill. So as with regard to the other, the last bill that we heard, the foundation for the reason behind this bill simply does not exist. And with that, I'd be happy to take any questions. Thank you very much.
Thank you, Mr. Head. Representative Lewicki, do you have a question?
Yes, thank you, Madam Chair, and thank you, Mr. Head. So I believe what I hear you telling me, and please tell me if it's not, is that while someone appeals their rights to the Supreme Court, those rights will be held in abeyance. Is that correct?
Not always. So we have, an order can be stayed pending review, either by the trial court's order or by the Supreme Court's order. So not necessarily.
Thank you. Any further questions? Seeing none, I will thank Mr. Head for his testimony. And I will read the sheet according to my sheet and what I have added up, and I will ask Representative Altshuler to correct me if I'm wrong. We had 1 in support, 3 opposed, and a total of 4 to testify. And with that, I will close the hearing on House Bill 495 and give the clerk a minute or so to finish up her work, and then we'll move on to House Bill 120.
Madam Vice Chair,
Yes, Madam Clerk.
if I could please ask people when they're introducing themselves to also add if they have a written testimony. I have quite a few pages of notes from persons. I do have many written testimonies printed out. That's why you see me running back and forth. But if they have written testimony, it will alleviate some of the writings that I'm doing.
Thank you, Madam Clerk. I will try in my brain to remember to ask them for that.
Okay, thank you.
Thank you. Are you ready? Thank you, Madam Clerk. The next bill I'd like to open is House Bill 120, relative to the administration of psychotropic medications to children in foster care. I see that I don't have that sheet. This bill is sponsored by Representative Marsh, and I see that he's here. Representative Marsh, you can unmute yourself and begin testimony.
Thank you, Madam Chair, and thank you for hearing House Bill 120 today. As the clerk requested, I did submit my testimony to the committee by email, so she doesn't have to write down everything that I say. And I also attached some supporting documents which you guys may want to consider here too. Record, I'm Representative William Marsh, Carroll County 8, representing 7 towns in southern Carroll County. And I'm pleased to bring you today House Bill 120 relative to the use of psychotropic medications for children in foster care. This bill was filed in response to the United States Inspector General's September 2018 report. Treatment planning and medication monitoring were lacking for children in foster care receiving psychotropic medication, which I've also emailed to the committee for the permanent record. Note especially page 23, which summarizes specifics relevant to New Hampshire, and which I also emailed to you separately for convenience. What the Office of the Inspector General did is to review Medicaid claims data and clinical records in the 5 states which reported the highest percentage of children in foster care receiving psychotropic medications. New Hampshire had the 3rd highest. It did this because the Administration for Children and Families is responsible for awarding federal funding to states' child welfare programs and for overseeing those programs. And they reminded us on page 3 of their report that if ACF finds that a state is not in substantial conformity with its state plan, it has the authority to withhold a certain amount of federal funding. What the Inspector General found is that 23.4% of New Hampshire children in foster care receiving psychotropic medications had no treatment plan. 37.9% had a treatment plan but no diagnosis on their treatment plan. As a doctor, I am most troubled that the total of these numbers is 61.3%, meaning that the majority of the kids in New Hampshire foster care receiving psychotropic medications had no diagnosis. And 21.8% of these children did not receive medication monitoring by a prescribing professional. House Bill 120 is actually a pretty simple bill. Last year with House Bill 1278, which was similar, which you guys sent to interim study, there was an objection to the department using rulemaking to limit the use of psychotropic drugs. In House Bill 120, we define medication restraint as the use of psychotropic drugs without a clinical diagnosis and apply the existing law in RSA 126U to such use. Medication restraint is specifically referenced in RSA 126U:1 Roman 4. So long as medical practitioners are treating disease, or in other words, list a diagnosis, this will never apply to legitimate medical treatment. This is similar to how we limited the use of psychotropic medications as a restraint in hospitals and nursing homes a generation ago. California passed a similar bill tightening oversight over the use of psychotropic medications in foster care in 2015, and it has resulted in a 45% reduction in antipsychotic prescriptions to foster care kids, and a 73% reduction in prescriptions for multiple psychotropic drugs. The Inspector General on page 31 of his report said that New Hampshire spent $1,741,581 for psychotropic medications for foster kids in 2016. While this bill lacks a fiscal note, I would contend that a similar 45% reduction in New Hampshire would result in a $783,711 savings to the New Hampshire budget. I also sent you Amendment 0517H, which addresses specific concerns brought forward by the New Hampshire Psychiatric Society. I'm sure they will speak to their word language changes. And in my opinion, it improves the bill without undermining my intent. So thank you, and I'll be glad to answer questions.
Thank you, Representative Marsh. Do I see any questions? Seeing none, I thank you very much for your time and introducing this bill and bringing it to our attention.
Thank you.
That said, I will now close the hearing on House Bill 120. Is that for 120? I don't have that sheet. Okay, I apologize. I'm not closing the hearing on that bill. I'm reopening it, and I see Moira O'Neill, child advocate, who would like to testify. Good morning, Moira.
Good morning. Can you hear me okay, Madam Chair?
Yes.
Great. Good morning, Madam Chair and members of the committee. For the record, my name is Moira O'Neill and I'm the state child advocate. I appreciate the opportunity to speak in support of House Bill 120 relative to the administration of psychotropic medications to children in foster care. We're very grateful to Representative Marsh for raising this bill. It's a very important issue. We support it, and we did work with New Hampshire Psychiatric Society to craft a few suggested amendments to the bill. But as he said, it doesn't change it, it just it strengthens it in protecting children. He has already referenced the Inspector General's report, which I think is very important to note and to guide this conversation. Children in DCYF custody are predominantly children who are victims of abuse, neglect, or other family dysfunction that causes a high level of adverse childhood experiences. And ACEs are associated with mental illness, communication disorders that often manifest as problem behaviors. And generally, removal from their homes is a response to the need for safety. But treatment that's prompted by the persistent symptoms of this mental illness or problem behaviors tends to be often more medication focused than otherwise. And so it's really important to be thinking about how we protect kids when they're receiving these medications. Anecdotally, the Office of the Child Advocate has reviewed a number of children's cases in which problematic changes in the child's behavior appear primarily addressed by medication changes. And in some of those cases, we've seen it later discovered that there were manifested behaviors that were caused by other underlying physical conditions. So we're really very concerned about not just monitoring the use of psychotropic medication, but also monitoring children's health in general. So some of the recommended changes that we've brought forward would, first of all, amend the definition of medication restraint to make the proposal in HB 120 consistent with the definition of medication restraint already in RSA chapter 126U. And for that, we would say, change the language to medication restraint is defined as the involuntary administration of any medication, including psychotropic medication, without a clinical diagnosis for the purpose of controlling behavior, unless it is to ensure the immediate physical safety of persons when there's substantial or imminent risk of serious bodily harm to children. We also suggest amending the title of RSA 169B, section 23 on page 1, line 9, to orders for health examination and treatment, and the term physical treatment as used on page 1, lines 10 to 11 to health treatment. Those are language changes, but what they do is they change to encompass both physical and mental health treatment. As I referenced you before, sometimes behavior change isn't a psychological problem, it's an underlying physical issue. So we want to make sure that we're comprehensively assessing children and also addressing the stigma that's associated with mental health treatment caused by separating physical and mental health out. It's all health for children. We further recommend that prior to prescribing psychotropic medications, the prescribing provider should first ensure 2 assessments are or have been recently conducted. One is a comprehensive medical assessment to rule out any physical or organic condition underlying the symptoms that the medication is intended to treat. And that will ensure the holistic approach, effective diagnostics and treatment, and also minimize the exposure to unnecessary psychotropic medications. And the next thing we recommend in terms of assessment is a comprehensive psychosocial assessment and a plan and implemented evidence-based treatments accordingly. Especially in the cases of young children, the professional consensus is to address psychosocial issues prior to, or at least in concert with, prescribing medications. Additionally, because of the unfortunate trends in inconsistency of placement of children, children's healthcare is not always consistently followed by any one provider or parent-like proxy, unfortunately, in the state. We feel that when a child sees a provider who prescribes psychotropic medications, the consultation should include the child's guardian and a DCYF nurse to ensure that they're aware and informed of the reason for the medication, the therapeutic intention of the medication, and any potential side effects that should be monitored. We also suggest that the bill include the expectation that any child in foster care who's prescribed psychotropic medications will be referred to a DCYF district office nurse for their monitoring of care and provision of informational support and guidance to the field staff and to the caregivers of the child. This provides for some consistent oversight if children are moving around and seeing different providers. To incorporate those suggestions, we recommend adding the following language. And I have submitted written testimony to you that has the pages and lines in them. So I'll leave that out, but that's just in the interest of time. It's there where we would change that language. We also recommend an amendment in terms of the duties of the department to ensure that DCYF district office nurses provide medication monitoring for children in foster care. That's more language there. There's no distinction in this bill about who prescribes psychotropic medication to children in foster care. And that's actually okay because the flexibility is necessary. As you probably all know, there's a chronic shortage of child psychiatrists in New Hampshire. But if we're codifying the use of psychotropic medications, it would be neglectful not to be sure that anyone prescribing medications has access to expertise and guidance to make the best decisions for children. There's an excellent model, several excellent models of support for primary care pediatricians who are willing to prescribe psychotropic medications with adequate support and guidance. I direct your attention to the Massachusetts Child Psychiatry Access Project, which is one of those models that provides a remote consultation and educational supports on best practices to primary care pediatricians. DCYF currently contracts with Dartmouth-Hitchcock for services of a psychiatrist at the Sununu Youth Services Center. And because the census has been so low there, he's actually had time to do some consultations on medication reviews of some children across the state. So his contract's not adequate to provide the level of support that we're thinking of to pediatric providers, but it certainly is a start and maybe something that could evolve into a program like the Massachusetts program that I recommend. So we suggest that being added in. And finally, centralized oversight of children's care is essential to identify trends across child experience. And so the bill calls for reporting to the Joint Legislative Oversight Committee on Health and Human Services. And we have found that reports that go to legislative committees are sometimes not always consistently monitored just because of, you know, the unfortunateness of a 2-year term in the legislature. So we recommend that in addition to that report pathway, that it also be sent to the Office of the Child Advocate so that we can do some consistent monitoring of the reports and report back to the committees as well. We've started doing that with looking at restraints and seclusion that's reported to committees. We're finding that it's very helpful to have someone who's actually monitoring and analyzing data that's coming in. I have also provided for your information at the bottom of my written testimony some details about the side effects of psychotropic medications, just so that you have some awareness of that. These drugs can really change lives. They can be very helpful, but they are also, you know, dangerous in children's brains when they're not used appropriately. So it's important to really understand the impact of them. And I'll stop there and thank you for taking my testimony. I welcome your questions if you have them.
Thank you. I see a question from Representative Lewicki.
Thank you, Madam Chair, and thank you, Ms. O'Neill. Do you know whether DCYF has the resources to implement this, which would be nurses and so forth?
Thank you for that question, and I'm happy to answer that. In the last biennium budget, there was funding for nursing positions. They are not all filled yet, but they are in the process of hiring them, and we're really pleased for that. DCYF had nurses in the past. And they were lost in the last 10 years, but they're back, and that's a really good role for them when children have special medical needs, that they're there to not just monitor the individual child, but also to give guidance to caseworkers who often are involved in decision-making, and guidance to the caregivers, whether they're foster parents or for biological parents who are in the process of reunifying, who need to really understand medications that their children are receiving.
Thank you.
Thank you. Next question is Representative Belanger.
Thank you, Madam Chair, and thank you, Maura, for attending our committee hearing today. You alluded to a low number of students at the SYSC Center, and just for curiosity's sake, how many students is that?
Thank you for that question, Representative Belanger. I believe today the census is around 12. It's been in the last few months 8 to 10. I think the average for the year DCYF is reporting is about 24, but we've seen consistently, hovering around 10, and I would say the last 8 months or so.
Thank you. No follow-up.
Thank you. Next, we have Representative Long. You have a question?
Thank you, Madam Chair. Thank you, Ms. O'Neill, for your testimony. A couple questions on the in the amendment. It asks for consultation with the child's caregiver. Does that include the foster care family?
Thank you for the question, Representative Long. Yes, that's what our intent was when we suggested, and I'm sorry, I don't have a copy of the amendment, so I don't know the exact language, but the person who's taking care of the child, and that may be a foster parent, or it may be, upon return to a biological parent, just so that whoever is with the child knows what medications the child is on, knows what the side effects are to watch for, knows what the intended therapeutic effect are, so that we know, whether it's safe and also effective. Like essentially how a parent would monitor, their own child's care.
Can I follow up, Madam Chair?
Follow up.
So the language says shall include consultation with child caregiver or legal guardian, and the DCYF, district nurse. So I'm thinking that the child caregiver is the foster parent. I'm looking to include the foster parent.
Yeah.
So I don't want the foster parent to be excluded if there's a legal guardian or the nurse suffices. But what you're saying is that language would include the foster parent, correct?
Thank you for the clarification, Representative Long. I think that's the intention. I think what we certainly wanted to include the foster, so the caregivers, anyone who's taking care of the child, which could be foster parent. Maybe that's a need for a definition there. But I'd also, listening to you read it out, I do get worried about logistics and wonder if we shouldn't have the language say and or when possible, because we're talking now about 3 people, the district nurse, the caregiver, and potentially the guardian, and we don't want to delay care because we can't get all 3 people into a room. But a consultation with them could also just be a phone call and a conversation and follow up.
Okay, and another one more follow up, if I may. Another question.
One more follow up.
Okay, you mentioned DCYF oversight. When reviewing the bill, I don't see specific DCYF oversight. I see Department of Health and Human Service monitoring, but it's not specific to DCYF. Would we assume that Health and Human Services would be the division of DCYF?
Thank you for that question. I guess I would assume that, and I'm sorry I didn't see that language. But if the DCYF nurse is there and monitoring, then that is DCYF oversight, I would assume.
Okay, great. Thank you.
And I guess I would add, in some cases, there may be employees from Children's Behavioral Health Bureau who are not DCYFs, but I believe that the nurses are DCYF employees.
Thank you. Will you take one more question?
I'm happy to, thank you.
Thank you. Representative Altshuler, you have a question?
Thank you, Madam Chair. Thank you, Dr. O'Neill, for being here. And actually, Representative Long asked all my questions, so I'm good.
Okay, well, I'm glad your questions were answered. Do we have any further questions? Oh, thank you, Dr. O'Neill, for your testimony.
Thank you very much for the opportunity.
And did you say that you submitted written?
I did, thank you. I forwarded it last night. If you don't have it, I'm happy to resend copies.
No, I thought I saw it. Okay. So thank you very much.
Thank you.
Next, we have Patrick Ho. You can unmute yourself, sir.
Hello, can you all hear me?
Yes.
Great, thank you. Good morning, Madam Chairman and members of the committee. For the record, my name is Dr. Patrick Ho, and I'm the president of the New Hampshire Psychiatric Society. My testimony represents that of the New Hampshire Psychiatric Society, as well as the New Hampshire Medical Society, of which I am an executive council member. I wanted to keep my testimony short today to cede most of my time to Maura O'Neill, but I also wanted to thank Dr. Marsh for his leadership on this issue and his enthusiasm in working with us at the New Hampshire Psychiatric Society, as well as the Office of the Child Advocate. We believe, as does Dr. Marsh, that it is important to ensure that children in foster care are able to access evidence-based treatment for general health and mental health disorders. As it pertains to psychotropic medications, it is important to note that in many cases, as Maura had said, these medications are appropriate for mental health disorders in children. However, we as a state have a shortage of psychiatrists and an even more pronounced shortage of psychiatrists with specific child and adolescent training. So our work with Dr. Marsh ensures that this bill will protect the welfare of our state's children in foster care while not impeding the ability of physicians to treat children in foster care with evidence-based measures. So with that, I will leave that there and once again look forward to supporting this bill alongside Dr. Marsh and the Office of the Child Advocate. Thank you for your time, and I welcome your questions.
Thank you, Dr. Ho. Do you have written testimony that you could submit to the committee?
I do not, but I can sure submit what the sentiments that I had spoken to today, and I will do that after any questions.
Thank you kindly. Do I have any questions for Dr. Ho? Seeing none, thank you for your time. Next, we have Rebecca Ross. Welcome. You can unmute yourself.
Good morning, Madam Chair, members of the committee. Thank you for the opportunity to testify. My name is Rebecca Ross. I am General Counsel and Legislative Liaison for the Division for Children, Youth, and Families. I do apologize. I have not had the benefit of seeing the amendment, so my testimony is based on as introduced. But we're happy to work with the folks that have drafted potential amendments and would welcome them reaching out and working with them on those amendments so that we can help build a better system for kids in foster care. To clarify a couple of the prior points and questions that have already been raised, with regard to Representative Long's question about DCYF oversight, the way that this would be focused on DCYF having control of the oversight is the statutes that are invoked, 169B, C, and D, as well as 170G. Those are child protection, children and native services, and delinquency, as well as DCYF services. So by way of including those in this bill, it directly connects to DCYF having the responsibilities over these functions. Additionally, I wanted to provide a little more information about the doctor at SYSC who is available to all of DCYF for consultation. It is included in his contract that he will be available for that work and to work with both the DCYF nurses as well as providers to children in the community. That was intentionally added into his contract when it was drafted. It was It is not just available because of the low census at SYSC. That was an intentional ask and requirement as we sought to have that doctor engaged for this express purpose. Taking a step back, I want the committee to understand that the department absolutely recognizes that our responsibility for the monitoring of psychotropic meds for children in foster care is an absolute priority. However, decisions should be made based on current and accurate information. And the OIG report uses data that was nearly 5 years ago. So although we're talking about the numbers that were in that as the driving force for that bill, it's not reflective of where we are today. One of the reasons New Hampshire's numbers are high are because we include the CHINS population and the delinquency population in our foster care data. Most other states do not. While even removing that population, we recognize we want to do better for the children and youth in our care and are addressing the issue. But one of the driving forces under those numbers is the way our data is collected and our inclusion of the entire population in the foster care system. So we have taken a number of steps that have already been discussed by Moira and other folks who have testified, including the ability to add nurses back in through the budget. We have nurses added to almost all of the district offices. There are a couple more to fill, as you, I'm sure, can appreciate. During COVID has been a difficult time to hire nurses, but we are almost there. And those nurses, one of their responsibilities under their new job descriptions is, in fact, to monitor psychotropic meds for children in foster care and consult with the doctor at SYSC regarding those youth. So we believe that is in place, it is building, it is growing. And as those nurse positions are all filled, we will do even better with that. The MCOs are also working on this. We've built things into their contracts to monitor the use of psychotropic medication for all foster youth as one of the elements that we monitor through the MCOs, and we score them, and we have compliance measures that have been built into the new contract. So we believe that will help improve this issue as well. We have some additional work to do with the collaboration between the MCOs and the division, and that is underway. I wanted to point out, as Moira did as well, that the definition was not consistent with 126U. We believe 126U does prevent that misuse of psychotropic medications as a restraint. It already does in the law, therefore adding this into 169B, C, and D is duplicative. But if it's going to be in both places, we would certainly like the definitions to be consistent for implementation purposes. Otherwise, we're just creating inconsistencies and confusion. So we believe we've taken a number of steps to do this, that this legislation, although well-intended, is not required because those pieces are already being built and put in place. With regard to the administrative reporting, while it is set up to go to HHS, we do question and would like you to consider whether that would be more appropriately directed to the Children's Oversight Committee that deals with a lot of the other issues for this population. And there are a number of items in the reporting that are not currently reported through the Medicaid system or reported in the way that they are described in the Medicaid system or our child welfare information system. And we believe it would be a substantial work to get them connected in the way that they are drafted. So we would like the opportunity to work with folks to decrease the further burden of additional reporting by working with data in a way that we have it and can combine it in a way that gets you the information that you need, but does not require manual data tracking that is very time intensive and just unnecessary if we have other ways to meet the needs of the committee. And I'm happy to take questions at any time.
Thank you, Ms. Ross. Representative Long, you have a question?
Thank you, Madam Chair. Thank you, Ms. Ross. So I just want to be, well, first of all, I commend the state of New Hampshire for including everybody. That's fantastic. So what I'm hearing is you're looking for consistency in restraints language and also with reporting, correct?
Yes, that's right. Just looking at the reporting requirements to make sure they're feasible within our current systems, that they don't have an unintended cost and burden, and that, as Moira had suggested, having the definition match the one that already exists in law.
And just to follow up, if I may, Madam Chair.
Certainly, follow up.
Yeah, with respect to both of those language, can the committee depend on you and the other parties involved to submit consistent language?
Yes, absolutely.
Okay, that'd be great. Thank you.
Thank you, Representative Long. We have another question from Representative Yochello.
Thank you, and thank you for taking my question. In your testimony, you said that this is duplicative or duplicative. There we go. Because we have a statute forbidding the use of psychotropic medications on as a restraint. This is seems to be more broad use of psychotropic medications. So are you saying that psychotropic medications are only used for restraint?
No.
So this is not necessary?
As the OCA explained, there are certainly appropriate times when they are medically necessary. This bill is looking at preventing the use of them for improper restraint and when they're not medically necessary. And that's already contemplated in RSA 126U that prevents the use of improper use of medication restraints. And this bill incorporates 126U in each of the sections, saying they shall not be used in violation of 126U, which is where it's already addressed.
Thank you.
Thank you. Representative Belanger, do we have any more hands up? We do. Representative Lewicki, you have a question?
Yes, thank you, Madam Chair, and thank you, Ms. Ross. I'm somewhat unfamiliar with this, and this is a general question. Approximately how many children do we have in DCYF care, and what the breakdown is to in foster care or other places, and how many of them are being treated with psychotropic drugs?
So I can get you that information to follow up. I don't have it in front of me and don't want to go from my memory because that would be dangerous right now. So I will get you that information. We do publish the annual report that has the information about number of children in care as well as our monthly dashboard. I will provide the committee with both of those links and highlight that exact information and try to collect from Medicaid that specific information on psychotropic meds and get it to the committee.
Thank you.
Do you have a follow-up? Okay, no. Any further questions for Rebecca Ross? Seeing none, thank you, Rebecca. Your testimony is great. And with that, seeing no further questions, we have another person to testify. It would be Michael Skibby. Mr. Skibby, you can unmute.
Good morning, Madam Chair and members of the committee. My name is Mike Skibby. I'm the Policy Director at the Disability Rights Center. I just want to touch on a couple of things. I won't go over the ground that's already been discussed. First of all, I want to thank Representative Marsh and the co-sponsors of the bill. I think this is very important legislation to address what I think everyone would agree is a significant issue, particularly in light of the report from a few years back. We support this bill. I have not seen the amendment nor the particulars of recommended changes to the bill that were discussed by Director O'Neill. I did want to comment, though, on just a couple of things. Just generally, you may know this, but I think some people don't, that there's an extremely high rate of disability in the child protection system. And there's a lot of scholarship on about why that is. I think it's generally understood that the dynamic basically runs in both directions. The existence of a disability may create vulnerability to abuse or trigger abuse or neglect, and the imposition of maltreatment on a child can cause disability itself. So, it probably would make sense to you that a child with disability can create stress in the family. A child with disability may be less able to apprehend that they are being abused or neglected or otherwise defend themselves. And I think it should be clear to everyone that being subjected to abuse or neglect or other trauma can cause disability, particularly behavioral health disorders. So I think it's important, especially important, that we ensure that children in the system receive appropriate behavioral health care. And that includes proper diagnosis and monitoring of treatment. I think that should be obvious. I think that the diagnosis issue, though, is worth pausing for a moment about. I think that it's in the nature of children's behavioral health conditions that proper diagnosis depends on, careful collection of information from the child's caregiver. And so many of these children will have come from homes where there was not a reliable caregiver who can describe the child's struggles with a treatment provider. So diagnosis is particularly challenging, and the need for careful monitoring of treatment may therefore be especially great, because that diagnosis may not rest on as solid ground as in other situations involving children. It may also be particularly important for the healthcare provider to work closely with the foster family or other caregiver so that their actions align with and support the treatment plan, which we can expect to be more challenging in the foster family setting than in the context of an ongoing, uninterrupted parental relationship. So those were a couple of things that I just wanted to emphasize. I have not seen the amendments, but my ears perked up when I heard the discussion of possibly changing the definition of medication restraint. And if I misheard, I apologize, but I'm concerned that the committee be cautious about amending the definition of medication restraint in Chapter 126U itself. And I have a bit of post-traumatic stress disorder about the history of that statute, because its original version basically had some definitions that incorporated language that made it very easy for the regulated entities to avoid regulation. And so if you were considering changing the definition of medication restraint to include what the purpose of the medication was, I think you need to be very, very careful about that. And so if that's being contemplated, I hope that there will be an open discussion about making sure that we protect the important elements of Chapter 126U. With that, I'd be happy to answer any questions.
Thank you, Mr. Skibby. Representative Long, you have a question?
Thank you, Madam Chair. Thank you, Mr. Skibby. So with respect to the assessments, there's a recent it needs a recent comprehensive medical assessment to rule out an underlying physical cause, and a comprehensive psychosocial assessment to address psychosocial issues. So that's the that's what is needed prior to the prescription. So a recent comprehensive medical assessment. Can you tell me what's that time? Is that 6 months, 8 months, 2 months, 3 months? Recent?
Boy, that's sort of the standard of care in the healthcare setting that I really would not be able to speak to with any expertise. I would comment, though, that ruling out physical causes for behavioral symptoms is an extremely important thing to do, particularly when you're dealing with children. I have a very close relative who was treated for years for behavioral health issues that turned out to have been related to an untreated infectious disease. And I've spoken to healthcare providers in the behavioral health field who about this case, and have heard that reinforced many times, that it is very common, or at least, it's a frequent occurrence, I should say, to find that there's a very close relationship between medical conditions and behavioral issues that might otherwise not be understood to be related to them.
And a follow-up, if I may, Madam Chair.
Follow up, certainly.
Thank you. The use of medication restraints shall be limited as provided in RSA 126U, which is in both the has introduced bill and the proposed amendment. And Ms. Ross and Ms. O'Neill will be looking for consistent language if you want to connect with them. So thank you, Madam Chair.
Thank you. I will do that.
Thank you. I see no further hands up, and I see no further. Oh, we do. A hand just came up. Cheryl Avery, you wish to speak on this bill?
I do. Thank you, Honorable Chair and members of the committee. I appreciate your time on this matter today and the opportunity to testify. My name is Cheryl Avery, and I'm the Policy Coordinator for Children's Behavioral Health at New Futures. And I appreciate this opportunity, and I have submitted written testimony, so I will keep this brief. I'm here today in strong support of House Bill 120, along with Representative Marsh's proposed amendment of today. This important legislation can go a long way in the effort to reduce the use of psychotropic medications and improve outcomes for children in New Hampshire's care. Certainly, similar legislation in other states has shown a dramatic decrease in the use of psychotropic medications. I also want to thank Representative Marsh for bringing this forward. Prior to my policy work at New Futures, I spent years working with children in New Hampshire, both as a guardian ad litem and within the residential placement system. And the issue of over-medication has always been a matter of serious concern. The IG's report that was cited by Representative Marsh has shown a light on this issue, and I'm hopeful that we'll use it to improve the care and treatment of our state's most vulnerable children. By tightening oversight and ensuring that every child who is prescribed medication has a proper diagnosis and a corresponding treatment plan, we can be more confident that every child in the state's care is receiving the proper care and treatment. I want to thank you for your consideration of this important matter, and I ask you to vote to pass HB 120 with the proposed amendment. Thank you.
Thank you, Ms. Avery. Any questions? Unless one pops up, I see no further hands up for anyone who wants to testify. Nope, nothing. So I will read what I have for statistics. Please correct me if I'm wrong. We have had 6 people testify. We have 0 opposition and 74 in support. And barring any corrections, with that, I will close the hearing on House Bill 120. I will also let you know that our next hearing is at 1 o'clock. So you're welcome to all go and have some relaxing time and lunch. And we'll see you at
Madam Chair.
Representative Long, sure.
Yeah, so with respect to amendments, a committee has to introduce the amendment during our exec session, correct?
That is correct.
But it doesn't have to be our amendment. It could be like Representative Marsh's amendment, correct?
That is correct. If there is an amendment that is sent to the committee, somebody will introduce the amendment during the exec session, and we will make motions on that amendment and discuss it at that time.
Okay, so with respect to 120, it looks like there's going to be additions to this proposed amendment. So if they send it to the committee, then we could introduce it. If there's a different amendment.
One of the members of the committee is welcome to introduce it. Yes.
Okay, great. Thank you.
You're very welcome. Any further discussion? Well, with that, have a lovely lunch. We'll see you at 1 o'clock. Welcome back, everyone that is back. I hope you had a good, relaxing lunchtime. Representative Alisea, Madam Clerk, are you ready to call the roll? You need to unmute.
I apologize.
Don't apologize. We just want to hear that lovely voice.
Representative Alt-Schiller,
Do you want to give it a few minutes? I think maybe some of them aren't back yet.
okay, sure.
Okay, we'll give it to 105.
Okay, thank you.
Okay, everybody who's back, according to my laptop clock, it is 1:05. I will again ask the clerk to call the roll.
Good afternoon, Children and Family Law Committee. Representative Altschiller,
Please state your name and who's with you and where you are.
I'm here. I'm Deborah Altschiller. I'm still in Stratham in my home office. Thank you.
Representative Belanger,
Thank you, Madam Clerk. I am in the LOB with Representative Wicki and Chairwoman, DeSimone.
thank you. Representative Cross, Madam Vice Chair, Representative DeSimone,
Thank you, Madam Clerk. I am here in the LOB with Representative Belanger and Lewicki.
thank you. Representative Grossman,
Hi, everyone. I am in my house in Exeter and I have one child with me in the house.
thank you. Representative LeVey,
Hi, I am here. I am still in the spare room.
thank you. Representative Lewicki,
I am here in the LOB with Representative Belanger and Representative DeSimone.
thank you. Representative Litchfield,
I'm here in my home in Brentwood. I do have 2 children and my husband here in the home as well.
thank you. Representative Long,
I'm in my house alone.
thank you. Representative Petrigno,
I'm here in my home office alone.
thank you. Madam Vice Chair, will someone be replacing Chair Rice this afternoon?
No, Madam Clerk.
Okay, thank you. Representative Denise Smith, Representative Wazir,
Yes, I am home with 4 of the kiddos still.
thank you. Representative Yokela,
Yes, I'm home alone still. Thank you.
thank you. Madam Vice Chair, so we have 15 members and 2 are not with us.
Thank you, Madam Clerk. Mr. Greenland, I guess the YouTube is a streaming service is all fixed. Never mind. Thank you. I just wanted to be sure that people can see what they should see. So with that, we will open a hearing on House Bill 293 relative to the procedure for adoption of a minor child. And I will recognize Representative Belanger from Rockingham 9. Could you please state who you are and open your bill?
Thank you, Madam Chair. For the record, my name is Representative Cody Belanger. I represent the town of Epping, New Hampshire, also considered the center of the universe. Today, I present my bill, House Bill 293, relative to the procedure for the adoption of a minor. There's also an amendment, and that would be 0590H, which I will address after this, but it addresses some other word changes that I thought would be necessary for this bill to be effective. While parents of these kids roam free and do as they please, and by these kids, I mean kids that are in the adoptive stage, filing petition after they are able to file petition after petition to get their children back. Many adoptive parents who also may be their guardians, whether related or not, are stressed. We need to be able to put the power back into these people, most importantly, these children. Studies have proven that kids need stability. Permanency is important. These families also need stability and permanency. It does no one any good when they feel like they are floating out in space, not knowing what the next steps are going to be. The importance of stability and permanency is always for the best interest of the child. Let me give you a few examples. My nephew, who I and my wife have guardianship of and are in the process of the adoption with, are trying, he has picked his own name, so he now prefers to be called Teddy. I say prefer because we haven't been able to legally change his name yet. But when my soon-to-be child comes out of his room during the middle of the night, or when we're cooking dinner, crying beyond belief, because he's worried that mommy's going to take him away. I can't tell you the pain that it causes me seeing how scared he is. And when he tells me, hurry up, I want you guys to adopt me, or why am I not adopted yet? I unfortunately have no answers. We are moving as fast as we can. And for the record, my wife and I are in the assessment process and are awaiting the social worker to be assigned to our home study. So this bill will not apply to us, but I'm putting this bill forward for the many families that are struggling just like we were. We have an opportunity to streamline the process for these families. There may be a statement made today that some would like to see an assessment done either on the front end or the back end, but need I let the committee know that that isn't there anyways. That part should be addressed in a separate bill regarding when guardians first apply for guardianship in the first place. Before you see an amendment. First line on line 5 that is struck out is for good cause shown. The reason why I strike that out, or the reason why it is struck out in this bill, is because if in lines A and B, which are renumbered to 1 and 2, and I'll get to that in a minute, these are already the causes shown that an assessment may be waived. So there is no further good cause shown required. The next change is on line 6. You strike out both to either instead. So the reason why I did that is because paragraphs 1 and 2 will blend into one and will read, the parents of the minor child have surrendered their rights, the parents of the minor child are deceased, or the parents' parental rights have been terminated, and the minor child has resided with the petitioners, which strikes out to whom the child is related, that was on the original bill, for at least, strike out 3, 2 consecutive years prior to filing the petition for adoption. That now would become one paragraph, and part B, which says, or an assessment has completed in the previous 3 years. The reason why I chose 2 consecutive years was, let me back up. The reason why I chose to add the parents of the minor are deceased or the parents' parental rights have been terminated, because not all situations the parent will surrender their parental rights. Sometimes you have to file for the termination in order for their rights to obviously be terminated. Sometimes the parent's child are deceased. So in order to make it more broad to apply to different situations, because not every situation is the same, I chose to add that wording. When you move down to line 11 for at least 3 to 2 consecutive years, it was brought to my attention that what about the kids who are in a home for 1 year, 3 months, 12 days, and they get replaced with mom and dad and then go back to potentially the petitioning adopted parents. That may or may not always be the case. And I would I would refer that question to Ms. Ross, who is on, how often that would happen, but this would mainly apply to private adoptions, and she will address that as well. And then the reason why I added line 12, that an assessment has been completed in the previous 3 years, is again, some of these parents, or soon to be adoptive parents, whether they're a relative or not, may feel that they have no idea the undertaking that they are bringing into their home and the care and quality of life that these children need. So they may take, for example, a foster parent class to better understand at-risk youth. So during that foster, if they choose to become foster parent licensed, there is an assessment there. It is a very different assessment, but it is not that different. What an assessment consists of is a background check, sex offender check, your previous 10 years of employment, tax returns, 5 references, one of them being a parent, one of them being a family member, and the other 4 being friends, and so much more. This bill's main intent is to reduce the number of years required from 3 to 2. In previous years, we have made changes to parental rights and how they may be terminated. I feel like this helps streamline this process, and I ask the committee, when it comes forward, please pass this bill with the amendment, and I will be more than happy to take questions.
Thank you, Representative. I see that Representative Long has a question.
Yeah, thank you, Madam Chair. And thank you, Representative Belanger. And also thank you for the love you're showing to your nephew, I believe you said, and for you and your wife showing that love. That's fantastic. He's a lucky child. So do we have a copy of the amendment?
It was sent to you in an email.
It was. Okay. Okay, it was sent by whom? The staff?
Me, sir.
Oh, from you?
It was sent yesterday afternoon around 1:30.
Okay.
When I received it from OLS.
All right. Okay. So the so an assessment, I heard you say that an assessment, there was 2 you referenced. So it would be any assessment like an IEP or what have you. I mean, it says an assessment, so I don't know if there are other qualifications of assessments that the court could deem is qualifying.
If I can answer your question, Representative Long, and thank you for your comments. I very much appreciate that, sir. No, if you read further the bill, if you further the RSA, there are certain outlines that is required and considered an assessment. So if I give my child an IEP assessment, that's not considered a statutory assessment for a quote home study unquote. It has to be, you could put the term home study in the assessment, and I believe it is quoted in the RSA. But when you talk about an assessment in this bill, which is statutorily explained throughout the RSA, which is 170-B, it is very specific as to the requirements needed in an assessment, quote, home study, unquote.
Okay, taking a follow-up if I may, Madam Chair.
Follow up, sure.
And in that, an assessment would also include your licensing qualifications. Is that what I heard? Oh boy. Is that what I heard?
It's not me calling. So if you, let me try to explain. So If you were a licensed foster parent, given a license provided to you by DCYF, there is an assessment that goes with that. That's addressed in line B. Or actually, another thought come to mind, if say I've had the child in my home for 2 years, we are petitioning for adoption, we've had the home study done, but for whatever reason, a child may be replaced with the parents, and then that doesn't work out, the assessment would apply for that as well. But private guardians do not, by petition to the court for guardianship, do not have foster parent licenses, and an assessment doesn't give that license to private guardians. I think I answered your question.
Yeah, no, you did. Yep. And just to follow up, if I may, Madam Chair, the striking of to whom the child is related, I think I understand that as to why should it just be related children? Is that the reason for striking that out?
So in my case, the child is related to me, but again, this bill, even if it passed tomorrow, would not apply as I'm currently in the process, nor would I accept this, as I consider it a conflict of interest. But anyway, to whom the child is related on line 10, striking that out. Let me give you an example. Prior to my nephew coming to live with us, he lived with my, what we consider his pseudo grandparents. He lived with them for about 2.5 years. Now, this was in Vermont, and unfortunately, Vermont's laws are not New Hampshire. Well, maybe not unfortunately, but Vermont's laws are very different from New Hampshire law. And she couldn't do anything to obtain custody of my nephew. But had they lived in New Hampshire and this bill would have been enacted, if they wanted to be the petitioning adoptees, this bill would be able to apply to them. Not every situation the child is living with a relative, but that may be the best place for the child to be. And I do want to drop one more comment, Mr. Long, and I appreciate the questions, but one thing to add is in all guardianship cases, in all adoption cases, a GAL is appointed by the court. And as I alluded yesterday, I was able to petition for my own. So that GAL still requires, is still required to draft a court summary as to what is in the best interest of the child. So that is still there as well.
Very good, thank you.
Thank you, Representative Wong. Next, Gabby Grossman has a question. Go ahead, Gabby.
Thank you, Madam Chair, and thank you, Representative Belanger, for bringing this forward. We've been involved with adoption cases with families, and our house has been used as a visitation site. So this is near and dear to me. My only concern, so private guardians ensuring that there is a home study at some point. So children cannot necessarily judge, making sure that someone is looking at the home. When you listed the licensed foster parent, there's a home study in that, but private guardians, is there a home study?
No. And again, as I stated in my statement, I do intend to draft a separate bill next session that would address that, but that won't apply here. I'll use myself as an example. When I filed for guardianship of my nephew, I thought that I would get some sort of background check. I didn't. I do plan to address that, but the intent behind this bill is just to reduce a number from 3 to 2. I do think that there should be at minimum, when applying for guardianship, as this person would be taking on a child, that a background check and other checks should be made, such as no abuse and neglect charges have been brought or potentially put on that person, as well as potentially a sex offender check as well. But again, that needs to be addressed on the guardianship side, which is a separate issue that would need to be brought forward.
I have Madam Chair, can I ask a follow-up?
Sure, follow-up.
Thank you. So in the process, whether it's 3 years or 2 years, is there a home study? Does anyone go visit the home that the child, like in your case, in the process, has anyone come, is it part of the process that somebody goes into the physical home? So not just record. I'm sorry, I'm losing my thought. I
think I got what you were trying to say.
Physically going to ensure that the home is a safe place, because the child may think it's a safe, but it may not be. The child at that time may not have the judgment, but who is ensuring from the state that we're placing these children in safe homes? If we're seeing that a home study, home assessment shall not be required.
So in a guardianship case wherein DCYF is not involved, short answer, no one. Long answer is if that person who is now remember, this only applies to the petitioning adoptive parents. If my nephew didn't live with me and I'm not applying for a petition, this would not apply and I could not have it assessed or waived, excuse me. So, geez, I just lost my train of thought. I'm sorry. I believe you said so anything under currently with the way that the law is right now, 3 years, there has been nobody that has come to my home. So my wife and I will have custody of my nephew 3 years this August. Since obtaining custody in August of 2018, we have never seen an individual visit our home to check to see if it's safe. Now, while I do own a very safe home, and again, should be addressed in another separate RSA, and I will get there. But yes, in 3 years that we will have him this August, not a single person has come to assess our home. And again, just reiterating this and beating this home, this only applies to an assessment if the petitioning adoptees are the ones petitioning for adoption.
One more follow-up.
And this may be too personal to answer, but I'm trying to get the landscape. In your case, is there DCYF involvement, or is this a private?
We need to stay on the subject of the bill.
I mean, I'll answer the question, Madam Chair, if that's okay. It's really quick.
That's fine. You're just not required to.
No. This is a private adoption case that I filed with the court as a pro se litigant at first.
Thank you. Just trying to get the landscape. Thank you.
You got it.
Thank you.
Next question's coming from Representative Altshuler.
Thank you, Madam Chair, and thank you, Representative Belanger, for taking my question. Just so we're all clear, and I'm looking at both your amendment 0590, and I'm looking at section 170B, and under section 18, it says that the courts have discretion to order an assessment at any time. Is that your understanding? And is that part of your thought process?
Yes.
Amendment together?
Yes. So that's not changing.
Okay. May I follow up, Madam Chair?
Yes, you can have a follow-up.
So this would change paragraph 5. and modify A and B. And it's my understanding, and please correct me if I'm not understanding this correctly, Representative Belanger. In section 6, directly after 5, section 6 says, notwithstanding any of the above requirements, the court shall require a background check in all private adoption proceedings if there has not been an assessment. So with your amendment, there's an either or. Has discretion to order that background check?
Yeah, so a background check is not the same thing as an assessment. The background check is
Understand.
just getting your fingerprints done at your local police department. So I did not want to touch that because I felt like that was important.
I'm sorry, just to clarify, Madam Chair, and I'm sorry, I should have clarified, Representative Belanger. Within the statute itself, for those who are not looking at it, I think it says the background check shall include a criminal records check and a search of the abuse and neglect registry maintained by the department. And so all of that, actually, none of that is changed with your amendment to section 5, correct? It does not supersede section 6.
Correct.
It won't negate that.
Right.
Thank you. Thank you for the clarification.
Thank you for the question.
Thank you, Representative Altschuler. The next question comes from Representative Yokella.
Thank you, and thank you for taking the question. Is it not the case that if there is a private adoption, then that is assuming that the parental rights have not been terminated, and therefore that the responsibility of making sure that the person now being set up to adopt is the responsibility of the current guardian and not the state?
I don't understand the question.
So it's in reference to Representative Grossman's question and your answer that no one is checking to whether or not in the situation of a private adoption that the home is safe. And isn't that responsibility on the current in the instance of a private adoption, isn't that responsibility on the current person's the current person that is having guardianship or before the adoption, or control of the child in that case before the adoption occurs?
If I think I understand your question, Representative Yokella, thank you. If I believe what you're saying is that is it the responsibility of the adoptive parent to provide a safe and safe home for a child?
No, I was yes. I mean, obviously that is the case, but I'm talking about who is responsible for making sure that the new adoptive parents are providing that safe location. Is that the current guardian? And because the state has not taken control of that guardianship, right?
That would be the guardian ad litem. So in any private, so I think I may have misspoke. In the going on 3 years that we have had custody of my nephew, there has been no one as guardians come to our home and check. However, a guardian ad litem could technically visit the home and provide not an assessment is probably not the right term to use there, but provide an lookout, if you will, of the conditions in which the home they are living in.
Okay, thank you.
And in that, she would provide that copy to the a report to the court.
Okay, thanks.
Do you have a follow-up, Representative Yokella?
No, I think I've got enough. Thank you.
Thank you. I see no further questions. And I see no further hands up. So with that,
No, we got hands.
we do. Oh, boy, these people are quick.
So they both jumped at first. Who would you like?
John DeJoy, you're welcome to begin speaking.
Thank you, Madam Chair. And I apologize for seeming so eager to raise my hand. For the record, my name is John DeJoy, representing Waypoint. And I want to thank the bill sponsor for the work he's done on this legislation and the way he's reached out to folks who've had questions and tried to remedy the concerns. He's done a significant amount of work on this. And I don't want my comments to reflect anything other than respect for his work. When we reached out internally in Waypoint to the clinicians who run our foster and adoption program when this bill came forward and talked to the bill about them, talked about the bill with them, there was one issue that they raised that we are concerned is not remedied by the proposed amendment. And that is a situation where a family member will self-place, drop off, if you will, whatever verb you'd like to use, a child with a family member. In those situations, if adoption is accomplished the way the bill discusses, it is possible that that home would not have any home study, either at the beginning or at the end. That's something that we think is a concern. We think it's easily remedied, but wanted to raise it as a concern. And the suggestion would be in the amended language, rather than the or between B and C, if we replace the or with an and, we believe that would remedy the concern. And with that, I will conclude my testimony.
Thank you, Mr. DeJoy. Will you take questions?
Of course.
Thank you. Representative Altshuler, you are welcome to ask your question.
Thank you, Madam Chair, and thank you, Mr. DeJoy, for entertaining my question. So in the event of your hypothetical with somebody self-placing, choosing a family member to place their child with, would not Section 5A still apply, that there would have to be a termination or a surrender of the parental rights through the courts, and would not trigger having a home assessment of where that child was when someone relinquishes their parental rights?
Representative, thank you for the question. That's an excellent question. I don't want to portray myself as an expert, nor am I. I would prefer not to guess at a response to that question, and I can tell you I do not have a clear response to that question.
Thank you.
Representative Long, you have a question?
Thank you, Madam Clerk. Mr. DeJoy, where again, you said between B and C, and I'm seeing A and B. Where would you replace the or with and?
Thank you for the question, Representative. And I'm trying to, as we speak, find the copy of the amendment that I reviewed. I'm not able to put my hands on it that quickly.
Okay,
Representative,
no, that's fine. That's fine.
I think line 11.
Line 11. Oh, okay, very good. Thank you.
my apologies. And now I have the amendment in front of me.
Thank you, Mr. DeJoy and Representative. Any further questions? Representative Lewicki.
Okay, thank you, Madam Chair. Thank you, Mr. DeJoy. Can you give us any idea how much an assessment costs? Is this something that is within the reach of parents, or is it a very expensive process?
I'm happy to get that information for you, Representative, and respond to the committee. I do not have that information. When I spoke to our adoption department, I didn't get into that level of detail. It was more, how should we approach this bill? So it was a much higher level, but I'm happy to talk to our adoption department and get a response for you.
Thank you.
Thank you, Mr. DeJoy. I see no further questions. I do see one. Representative Yokella.
Thank you for recognizing me, and thank you for taking the question. Kind of on the same topic that I just mentioned, especially since you are speaking to that, isn't it? So you're saying that in private adoption situations, that the current guardian essentially places the child in what they believe to be a suitable home, and your statement seems to be that the government needs to go and double check that, even though their rights have not been terminated yet. Is that your position?
Not exactly, Representative. Thank you for the question. What I was referring to is not private adoptions. What I was referring to is unofficial placements, where a particular family member, for whatever personal reason, will decide they cannot properly care for their child and will place that child with another family member. We believe it is typically preferable for a family member to care for a child of the family. Our concern, though, comes in with these unofficial placements if it moves to an adoption, that the adoptive family might not have any scrutiny. That's our concern. It's my understanding that private adoptions have a formal process that they follow as well.
Okay, thank you. I'm going to give it 30 seconds to see if anybody's quick and puts their hand up. I don't want to miss anybody's question or testimony. Gabby Grossman, there you go. Go ahead.
Thank you, Madam Chair, and thank you, Mr. DeJoy. It's so good to hear you. Not see you, but good to hear you.
Thank you, Representative. It's nice to be here with the committee as well.
So in those unofficial placements where maybe parental rights haven't been surrendered, the unofficial placements, is there DCYF involvement?
When there is some formal involvement, we're less concerned. It's when there's no DCYF involvement that we're concerned. So the illustration that was given to me is a family member has a particular personal crisis, cannot care for their child, and decide that aunt, uncle, grandmother, brother, sister, whomever, here, I need you to take responsibility for my kid. I can't do it. And that parent at some point just doesn't come back for whatever reason. And the custodial parent at that point moves for adoption. So I'm not trying to purport that this is a frequent occurrence. What I'm trying to suggest is that this is a potential occurrence that causes us concern.
Thank you.
Thank you. Another question from Representative Yokella.
Thank you, and thank you for taking the question. So currently, if the private placement happens and the 3 years, the child is with them for 3 years, no assessment is required, but you're trying to also change that policy in that with this change, right? Because it's currently not required if they're with them for 3 years. But you're suggesting that it should be changed to require that now, right?
We believe that many families who foster have an assessment of their home done before they begin fostering. Other families, when they adopt, have a home assessment. What we're suggesting is that it ought not to be both, but it should be at least one or the other.
Thank you for your answer.
Thank you. Any other questions for Mr. DeJoy? Thank you, Mr. DeJoy, for your testimony and the answers to questions.
Thank you, Madam Chair.
Thank you. Next, we'll hear from Rebecca Ross. You can unmute yourself.
Good afternoon, Madam Chair and members of the committee. Thank you for the opportunity to provide testimony. For the record, my name is Rebecca Ross. I'm General Counsel and Legislative Liaison for the Division for Children, Youth, and Families. The division takes no position on this bill, partly because we do not believe that it would impact DCYF related cases. We've heard a lot of different discussion about various parts of the system. I'd like to provide some clarification as to the roles, responsibilities, and the process and how this fits into that, so you can understand why we do not believe it applies to DCYF related cases. In the first instance, to clarify guardianship, when there is a private guardianship, DCYF is involved in that we receive a request for a check of our central registry directly from the court. When anyone files a petition for guardianship of a minor under RSA 463, they're required to give consent to be checked on the adult registry that goes through Elderly and Adult Services, a criminal records check through state police, and a central registry check for us. We process, I just checked the number and I apologize, I forget, but hundreds and hundreds of those a year for the courts, and send them directly back to the court. So everyone who's appointed a private guardian through the judicial branch is checked on our central registry if they are seeking to be the guardian over a minor. And that is the level of our involvement if it's a private guardianship case. In cases where DCYF is involved, we look at homes at a number of different times and places throughout a case. One, if someone is seeking foster care licensure, we do a look at the home for the purpose of the license. If they become licensed at the time we place a child, there are eyes on that home as well. Further, if the case does move to termination of parental rights and reunification is not successful, then we do an adoption home study, which is looking at, is this home in the best interest of the child for permanency and to make it their permanent family. So we are looking at that home at a number of different times with different lenses throughout the life of a case. If we are not involved and it is a private guardianship and a private adoption, then our involvement is by way of licensing child placing agencies who are regulated under 170E and under our administrative rules, HEC 6448, which require the elements of that home study. And that study is looking at whether or not that's, for adoption purposes, the best option for permanency and adoption. They also do home studies for foster placements under that child placing agency license. So it's very complicated, the times and places that the division or a licensed child placing agency is involved. But we believe this does not touch on most of those areas, and the bill is tailored to the cases where it is in fact a private adoption. DCYF has not been involved. It is not a licensed foster home, and the court through the judicial branch has vetted that home, has agreed to placement, has required annual reports and reviews to go back before the court, and then considers the adoption petition under this statute. I'm happy to answer any questions, but I hope that provides some clarity.
Thank you. Do we have any questions? Gabi Grossman, you have a question?
Thank you for taking my question. And so just to clarify, the last sentence you just said, in a private adoption, the judicial branch oversees that home study before agreeing to the adoption?
Yes, the judicial branch is the one that requires it and sees it when a petition is filed. It is the law that requires it to happen or be waived under certain circumstances. So DCYF is not involved other than being the entity that regulates child placing agencies who may be doing that assessment.
Thank you.
You're welcome.
Thank you. Representative Altshuler, you have a question?
Thank you, Madam Chair, and thank you, Ms. Ross, for taking my question. My question is with reference, you just made a reference in your testimony to the judicial, to rules and the statute that you follow, and I'm looking at 170, and it looks like in 170C9, there is a social study prior to disposition. Is that what you're referring to, that a social study is made by the Department of Health and Human Services or another agency?
So that is the social study that is done under 170C when we are petitioning for termination of parental rights. Additionally, under 170B, if we were doing the petition for adoption following a termination of parental rights, we would an adoption home study specific to that home and the statutory requirements under 170B. So we certainly do that study under 170C when we're trying to meet our burden under termination and provide an adoption study report at the time of the adoption matter.
And follow up, Madam Chair?
Yes, Representative.
Thank you. So just to follow up on that thread, as this bill is written, and I'm just dealing, I'm looking at the amendment, but also in the original. It says if either of the following circumstances are met, the parents of the minor child have surrendered their parental rights, the parents of the minor child are deceased, or the parents' parental rights have been terminated. So under surrender and terminate, back up, under deceased, would DCYF not be working with probate and under the probate courts and under surrender of rights and termination of rights, would not DCYF be involved with that child?
Not in all of the cases, no. For example, if the parents die and a grandparent immediately goes and gets guardianship through the judicial branch and there is no report of abuse or neglect, DCYF would not be involved. So I think it depends on under both of those circumstances. Sometimes we are, sometimes we are not.
Thank you.
Welcome.
Thank you. Representative Long, did you have a question?
Oh, it's been addressed. Thank you, Madam Chair.
Thank you, Representative. Seeing no further questions. Thank you, Ms. Ross, for your testimony. And we will now move on. I show no further hands of people who want to testify. So with that, I'll read the stats for House Bill 293. We have 5 people or more in support. We had 3 people testify. And with that, I will close the hearing on House Bill 293. I'm going to give Madam Clerk a few minutes to get herself together, and then we will open our 1 o'clock, which is late by 1:30 rather, which is late by almost 30 minutes. And I apologize to Representative Massimilla. But our questions and testimonies on every bill are extremely important, so just as it will be for yours. So as soon as the clerk is ready, we will begin.
I'm all set, Madam Vice Chair.
Thank you, Representative Alicea. I will now open House Bill 562 as introduced, exempting the victims of trafficking in persons from participating in children in need of services proceedings. Representative Massimilla, would you like to open with your testimony? Representative Massimilla, are you there?
Thank you, Madam Chair. Can you hear me?
Yes, we can. Thank you. Good afternoon.
Good afternoon, Madam Chair and members of the committee. I introduced House Bill 562, and what I would like to respectfully request is that the committee retain the bill. The reason why I'm asking for a retention is simply because last week HHS got in touch with me. We had a conversation at the end of the week with their concerns. And then we were going to amend the bill, but I was contacted by other people with other concerns. And so we mutually agreed that if we could have time to work on the bill collectively, that it would improve it and make it better. And therefore, we were asking for the bill to be retained.
Thank you, Representative. Any questions for the representative? Seeing none, I thank you so much for your request, and I thank you for your testimony.
Thank you, Madam Chair.
Next, we will move on to Keith Keening. You can unmute yourself, and we'd love to hear what you have to say. I guess Mr. Keening doesn't want to speak right now. So, excuse me. He just dropped. Maybe he'll come back. So right now we have Rebecca Ross with her hand up. She'd like to testify, I believe. Rebecca, you're on.
Good afternoon again, Madam Chair and members of the committee. Thank you for the opportunity to provide testimony today. We appreciate the conversation and work we've had with Representative Massimilla and agree that retaining the bill for further work is the appropriate approach at this time. Briefly, I'd like to explain that we had concerns that removing the availability of the CHINS program, which we see as a service-driven program rather than a punitive program, would have an unintended consequence of removing one of the doors to treatment and services available to minor victims of trafficking. We think there are some other ways to approach that besides closing the door completely, and have agreed to work on that language and approach going forward. So we appreciate Representative Massimilla hearing us and look forward to working with the representative and other individuals who had some concerns about this bill, and I'm happy to take any questions.
Thank you. Do we have any questions for Ms. Ross? Seeing none.
Madam Chair.
Representative Alicea.
I just need Ms. Ross to share, I believe she's the liaison for children and family. If she could just share again what her, her role is.
Yes.
I am General Counsel and Legislative Liaison for the Division for Children, Youth, and Families at DHHS.
Thank you.
You're welcome.
One of these days I'll get it, Representative Alicea. so I can make your job a little bit easier.
Sometimes I can remember, but I didn't remember her full title.
Okay, so next we have Joey Smith. Are you there?
Yes, I am. Thank you,
Great.
Madam.
Welcome.
So good afternoon, Madam Chair, members of the committee. My name is Joy Smith, and I'm the program director at the New Hampshire Coalition Against Domestic Violence. We're the umbrella organization for the 13 community-based crisis centers in New Hampshire. I'm also here representing the New Hampshire Human Trafficking Collaborative Task Force, which is a group of law enforcement officers, service providers, attorneys, state agencies, and community stakeholders dedicated to improving the statewide response to human trafficking in Granite State. I am here to speak in opposition of House Bill 562, a bill that would weaken the service provision for victims of human trafficking by exempting them from participating in the New Hampshire Children in Need Services, or the CHINS proceedings. I really appreciate everybody giving me the opportunity to share this testimony today, and I am in agreement with what Attorney Rebecca Ross from DCYF shared earlier regarding CHINS services in New Hampshire. And we're also really grateful to Representative Massimilla's commitment to improving New Hampshire's response to human trafficking. And we really look forward to collaborating with her on future legislation. We certainly appreciate her willingness to work with us in finding solutions to strengthen services for human trafficking victims in the state. The Coalition and the Human Trafficking Task Force are not aware of any problems with our current CHINS process here in New Hampshire, and we do have serious concerns with the impact that this legislation would have for child victims of human trafficking and their families. CHINS proceeding in New Hampshire are a non-punitive way to ensure that the children get the services they need after experiencing abuse, and victims of human trafficking are exposed to significant amounts of trauma, and it is essential that we are connecting them to the best resources available to them as part of their healing process. In my role as the program director and in previous capacities as a confidential advocate, I've seen firsthand how effective these services are for children and families here in the Granite State. Children who've experienced trauma such as trafficking, they require a holistic support, and CHINS is able to provide that with dedicated staff providing individualized counseling, guidance, supervision, treatment, and rehabilitation. So, you know, we certainly urge that we to vote no on this, on House Bill 562, and I appreciate everybody's time, and I'd be happy to answer any questions that you may have.
Thank you. Do we have any questions? Seeing none, I'll thank you for your testimony and thank the entire committee for all of its work. In the last 2 days, committee members, we have gone through 12 very emotional bills. I thank you for all your hard work putting up with me in my infancy of sitting in as chair, and appreciate your patience. Please stay tuned to your calendar to see when we'll meet next.
So, Madam Chair, did you close the hearing on 562?
I have closed. I apologize. Thank you. Keep me on my toes, Representative Long. I will close the hearing on House Bill 562. Where's my stats? My stats here show there are 38 in support, 2 in opposition, and we had 4 people testify. And with that, we will close that hearing, and we will be meeting next week. Representative Belanger tells me. So stay tuned for what time and place, and we'll see you then. Thank you, and drive safely and stay safe.
So So we don't, oh, so it should be
Yes.
in the calendar, right? That the day that we're meeting in the calendar should be in the calendar today.
I believe it's the 11th, but yes, it'll be in the calendar.
Okay. Oh, yeah, okay. Okay, 11th, yeah. Okay, thank you.
You're welcome.
Thank you, everyone. Have a good day.
Thank you.